National Federation of Labor, NFL versus Eisma, GRL 61236, January 31, 1984. Facts. On March 5, 1982, the National Federation of Labor filed with the Ministry of Labor and Employment a petition for direct certification as the sole exclusive collective bargaining representative of the monthly paid employees at the Lumbayao manufacturing plant of the Zamboanga Wood Products Incorporated, or Zambowood. On April 17, 1982, such employees charged the firm before the same office for underpayment of monthly living allowances. The union issued a notice of strike against the firm, alleging illegal termination of Junicio Eschoca, the union president, unfair labor practice, non-payment of living allowances, and employment of oppressive alien management personnel without proper permit. The strike began on May 23, 1982. On July 9, 1982, Zambowood filed a complaint with the trial court against the officers and members of the union for damages for obstruction of private property with prayer for preliminary injunction and or restraining order. The union president filed a motion for the dismissal and for the dissolution of the restraining order, and the opposition to the issuance of the writ of preliminary injunction, contending the incidents of picketing are within the exclusive jurisdiction of the labor arbiter and not to the court of first instance. The motion was denied. Hence, the petition for certiorari. Issue: whether construction of the law is required to determine jurisdiction. Held: the first and fundamental duty of courts is to apply the law. Construction and interpretation come only after, if it has been demonstrated that application is impossible or inadequate without them. Jurisdiction over the subject matter is a judicial proceeding, and it is conferred by the sovereign authority which organizes the court, and it is given only by law. Since the jurisdiction of courts and judicial tribunals is derived exclusively from the statutes of the forum, the issue should be resolved on the basis of the law or statute in force. Therefore, since, number 1, the original wording of Article 217 vested the labor arbiters with jurisdiction. Number 2, since Presidential Decree 1691 reverted the jurisdiction with respect to money claims of workers or claims for damages arising from employer-employee relationships to the labor arbiter after PD 1367 transferred such jurisdiction to the ordinary courts. And since, number 3, BP 130 made no change with respect to the original and exclusive jurisdiction of labor arbiters on money claims of workers or claims for damages arising from employer-employee relations, Article 217 is to be applied the way it is worded. The exclusive original jurisdiction of a labor arbiter is therein provided for explicitly. It can only mean that a court of first instance judge, then a regional trial court now, certainly acted beyond the scope of the authority conferred on him by law when he entertained the suit for damages arising from picketing that accompanied a strike. The Supreme Court granted the writ of certiorari and set aside and nullified the initial order of the court a quo. It granted the writ of prohibition and enjoined the judge of the said court from taking any further action on the civil case except dismissing it.